Hello guys, welcome all of you, and today we will be discussing about the UPSC Law Optional Paper 1. So this year, this is really surprising for all of us that the paper is really very easy. And UPSC has asked very simple, straightforward questions, and I believe many of the students are going to score very high marks this time. So let us see what happens ultimately after the result. But anyhow, the paper was really very easy, and if you understand how to write down, how to attempt those questions, then obviously you are going to make a seat of yours in final list. So guys, starting with this question number 1, part 1. Please read the question seriously, and then we will discuss about what kind of contents you should have written in this answer. So starting with this question, Preamble of the Indian Constitution So, Preamble of the Indian Constitution is indicative of basic values that the political system is expected to pursue. How far do you agree with this statement, and explain with the reference to the values that have been enshrined in the preamble of the Constitution? So if you guys remember what exactly has been given in our preamble and what are the contents you should write in such a case, so you could have write a better answer. So there is no need of applying your mind unnecessarily. The simple point is preamble has been indicative of certain basic values, and whether we have really achieved those particular things in our political system or not. So you have to just mention with the help of the examples. Okay, so about those values. So what kind of values we have been given in our Indian Constitution preamble? So guys, if we refer in preamble, total 10 values have been given. Actually, there are 9 values, but I tell you 10 values. So one is, if you refer, it is republic, then justice, then liberty, then equality. After equality, then we have been given fraternity. After fraternity, you can say, these are the main parameters, and after that, after fraternity, we can talk about these words, and then we can go with this initial parts of this preamble, which are about, you can say, socialist, secular, sovereign, then democracy. So 5 and 4, 9, and last, as I mentioned you, 10 values. So ultimately fundamental duties as well. Fundamental duties. So now you have to relate whether we have really been able to achieve these things in our political system or not. So in this case, now you have to just explain these 10 values one by one. So you can start with the socialist, secular, sovereign, democracy. So sovereign, when you do not have the interference of any other state, any other country, because it is more of international concept. Similarly, when we call about the secular, as we know that India doesn't have any specific religion to pursue. So we are neutral about this. And then socialist, obviously all policies of the government are concerned with the socialist kind of system, whereby we try to provide, you can say, that planned and coordinated way of this social development. So various social development policies have taken place by the government. Then democracy, obviously largest democracy of this world, and ultimately whereby you can say it is the will of the people which decides who will rule the country, because ultimately we are a republic as well, where there is no place of monarchy. Head of the state is ultimately from the, chosen through the will of the people. So it is not a hereditary or not a monarchy kind of thing. Then justice. When we come to justice, so ultimately social, economic, political, or you can say like these kind of justice one should have, and all kind of justice you can define, because remember one thing, it is a 10 marker question. So if you are able to point out these 10 points one by one and you can just write down 1 or 2 lines, your answer will be sufficient. So unnecessarily do not drag this answer. So just mention these 10 values one by one, explain each of these values and just relate in that line only how this is enshrined in our political system. Similarly, if you come with this liberty or equality or fraternity, how these things have been taken care. Like for example, if I talk about the fraternity, ultimately it is talking about the brotherhood, and it is mainly concerned with the dignity of the individual or the equal participation. Similarly, when we talk about the equality, so whereby everyone is equal. So ultimately, this is about fair and just treatment of all persons. So if you relate, like ultimately, the question is asking, explain with the reference to the values that have been enshrined in the preamble of the constitution. So they are, in the political system. So are we able to able to achieve them or not? So by this way, you can just relate how these things have been actually inculcated in our political system. So this is the way you have to just attempt this question. और एक बार ध्यान रखना, unnecessarily कुछ और ऐड करने की मत सोचना कि सोचो कि I should write something else, something different. No, question is very simple, so answer should be that only. Okay, that's all. Now moving towards next question, part B of question number 1. The office of the president of the Indian constitution is indicative of the basic values that the political system is expected to pursue. So guys, if you go by this question, preamble of the Indian constitution, sorry. Yeah. The office of the president under the Indian constitution has been designed to be largely that of a figurehead. Explain with reference to the cases decided on the subject. Regarding the president, first of all, you should be very well aware about the relevant articles. And when we talk about the relevant articles, you can mention Article 53. You can mention Article 53, Article 54. These are the main 2 articles, and along with this Article 57, Article 78, Article 79. I will not delve into these articles because you know very well about these articles. The question is about, they are talking specifically about that president is just a figurehead. So over here, I would like to mention you that you can quote the statement of few persons in this regard, because this particular statement was given in a specific context, and the context was, I will just tell you. So we have been given certain statements by like K.T. Shah. You can quote K.T. Shah over here. You can also quote B.R. Ambedkar ji. You can also quote over here this B.N. Rao. But besides all this, the most important person is K.M. Munshi. Who said that? No, it is not really a figurehead only. So if we go by the statement given by these persons, the statement of this K.T. Shah over here is relevant for all of us. So ultimately, K.M. Munshi was the person. I tell you the statement of these persons first. So K.T. Shah said that it is a, president is a sort of, you can say, like mere gramophone of the prime minister. So K.T. Shah told about he is just a gramophone of prime minister. It was the B.R. Ambedkar ji who said that our president is merely a nominal figurehead. So he said that our president is merely a nominal figurehead, and he has no discretion and he has no power of administration of all. So this particular statement was given by Dr. B.R. Ambedkar. Okay, and B.N. Rao also said that Indian president is only, like you can say, he reigns and does not rule. He reigns but does not rule. But it was K.M. Munshi who said that no, it is not a reality. So K.M. Munshi said that, and the statement of K.M. Munshi is notable over here, and those points we can also quote, like how president is basically, not only just a figurehead. Because if we go by, Article 78, and if we go by some situational factors as well, like for example, and the examples of Dr. Rajendra Prasad or Dr. Sarvepalli Radhakrishnan, when they were the president, so they have differed with the views of the government. So what you can do over here, first you can start your answer with these relevant articles, and then you can mention the statements of these persons if you have time. Otherwise, you can quote specifically B.R. Ambedkar, and then you can mention whether you agree with this statement or not. So you can quote the certain examples, certain situations whereby president has not agreed with the Council of Ministers or the Prime Minister only. So like for example, disagreement with the government, many times we have seen in the past. So Dr. Rajendra Prasad, Dr. Sarvepalli Radhakrishnan were, the best examples to quote over here. President has the power to return this decision of the cabinet, the proposal given by the cabinet. He can return that, and for once only, that is the issue, but ultimately he can return. And moral authority, and also you can say like president is considered in India is not only a figurehead but as a defender of the constitution. So you have to relate all these points over here to just give this answer of this particular statement. So it is up to you whether you just want to write down, because ultimately this question came in context of the recent issues with Ramnath Kovind ji or Draupadi Murmu ji, because the opposition leaders were saying that they are just the rubber stamp or figurehead. Ultimately in this context only this question came, but ultimately I do not agree with this. So even when Pranab Mukherjee was appointed as the, he was appointed as the, not appointed, but when he became president of India, he was from the Congress party, but when he was a president, ultimately he actually performed his duty as the president. So if it is not necessary that all the time, because ultimately no doubt that the process of the selection of president is somehow the ruling party may have this discretion, but ultimately it is not the reality all the time. In the past we have seen such kind of instances whereby president worked just like a rubber stamp, but it is not the reality as such. So it is up to you in what context you want to write down this. Okay, now moving towards next question. There is an obvious slant in favor of the center in distribution of powers between center and states. So do you agree with this statement or not? So in this question, guys, this question is about the distribution of power specifically between the center and the state government, and no doubt that obviously there is the distribution is basically in favor of the central government. So whether do you agree with this statement or not, so you have to just explain this. I agree with this statement, and I am also happy that this is there, because ultimately we do require a strong center, because we are a holding together kind of constitution, ultimately holding together. So that is the reason the kind of federalism, the kind of the power distribution is there. Obviously we do require a strong center, so that this India should not be divided once again as happened in the past. But anyhow, we have to mention about the relevant articles, relevant provisions. So what we can do, You can bifurcate, you can simply mention that the kind of, the distribution of power, the legislative relations, administrative relations, and the financial relations, and the relevant articles you can quote over here. Like, for example, from Article 245 till Article 255, we have been given this legislative relations. Ultimately, this is the main point, because Article 245 and Article 246 is the main thing which you should quote over here. Then Article 256 till Article 263 you can quote over here. And similarly, when we talk about the financial relations, you can quote over here Article 268 till 293. So these articles you can quote over here as a support of like how the distribution of power has taken place. And then you will come to the main point. The main point is the territorial distribution, Article 245. And you can also quote extraterritorial distribution under Article 245, Clause 2. And you can also mention over here doctrine of territorial nexus. Then you can quote about Article 246 when the distribution of the lists have been given. Okay, that you can also quote. You can also mention this union list, state list, and concurrent list. And then you can mention about the relevant cases if you really want to mention, like A.H. Wadia wala case, A.H. Wadia you can quote, Wallace brothers case you can mention over here, RMDC case. So these cases you can quote over here. RMDC, Wallace brothers, or A.H. Wadia case. So basically in this question you have to just mention about how the distribution has given shape in the Indian Constitution, and then you have to just explain why this is in favor of central government. So you can give your view. So this is all basically you have to mention in this particular question. Okay. Now moving towards next question, that is, the principles of natural justice are not cast in stone, and there is always a possibility of the deviation from the stated principles of law in view of the overall demands of the justice. Explain citing decided cases on the subject. Now in this particular case, it is talking about the principles of natural justice, and specifically this is a part of the administrative laws chapter, this subject. So it is saying that the principles of natural justice are not cast in the stone, and there is always a possibility. Actually, first you explain what is principles of natural justice. What is principle of natural justice, and what are the the maxims or the law, the rules of this principles of natural justice, which is first nemo, jodex, causa, sua. And then you can mention about this concept of odi alterum partem. Initially these were the two maxims which were given in this principles of natural justice, but with the passage of time we come across another maxim, another pillar of this principles of natural justice is called reasoned decisions. So actually this third pillar came out of, you can say, this situational factors. In the beginning, when principles of natural justice concept came, only it was concerned with these 2 points, but subsequent to this, with the requirement of the situations, we come out with this reasoned decisions as well. Now the question is demanding you that you should mention the decided case laws. So which case you can mention over here? Obviously we should we should focus upon that. So one of the case you can mention is State of Punjab versus Bhag Singh. And we do have another case called Kranti Association Private Limited. Kranti Association Private Limited versus Masood Ahmad Khan. These are the two cases in which it was held that in case of principles of natural justice, if any decision is being taken by the authorities, the adjudicative authorities, they should also quote the reason behind that, why they have come out with that particular conclusion. So basically, whenever any adjudicating authority, they are coming out with any kind of conclusion to any given issue, they should specifically quote what was the reason behind that. So this is called reasoned decision. So you can say, as per the requirement of the changing time, we do require changing the laws as well, changing principles. So ultimately, principles of natural justice is not a kind of the fixed concept of law. It changes as per the requirement of the time. So this is the point. This is the way how you should write down this particular answer. So you can quote these two main cases, State of Punjab versus Bhag Singh and Kranti Association Private Limited versus Masood Ahmad Khan. So these are the two cases which are sufficient for you to write down in a 10 marker question. That's all. Now the next question is, explain and elucidate the grounds of judicial review for administrative action by quoting decided cases on this subject. So it is a very simple question. Judicial review of administrative action. In what situations judicial review of the administrative action can happen? So basically, ultimately, first of all, you should mention about one landmark case, that is AK Karaipak versus Union of India, in which it was held that whenever there is an the use of power, or so basically when any administrative authority use the power, so the consequences must be taken care. So ultimately, judicial review is an integral part of this particular thing. So judicial review can happen. So any administrative authority, judicial review power cannot be taken away. So under various articles, we do have this judicial review power, like Article 13, Article 32, Article 226, even Article 14, Article 19, Article 21. So they basically provide the fundamental basis upon which this judicial review of the any administrative action can take place. First of all, you should start with this only. Now coming to this, what are the various grounds of judicial review? So first you explain what are the various types of the judicial review. So first of all, you can mention about procedural review. Procedural review. Second, you can mention about this substantive review. Then we have been given this legality review, and we have been given jurisdictional review. You explain about these reviews in one line. Like in case of procedural review, generally we see whether the process used by the administrative authority has been used properly or not. Then substantive means what are the merits of the decision of any particular decision taken by the authorities. Legality is about the powers, and jurisdictional is about the whether they have used their power within their jurisdiction or not. Then coming to the main grounds of this judicial this review. So ultimately, one of the ground is, you can say, on the ground of the reasonableness. On the ground of the reasonableness. And second is about proportionality, on the grounds of proportionality. These are the main two grounds on which judicial review can happen. So when we talk about the reasonableness and proportionality, then what you should write over here? So when we talk about this proportionality, the reasonableness basically, so it means the decision of the authority should be fair and should be in public interest. It should be reasonable, taken in the interest of the public justice, public interest. And when we talk about the proportionality, it means the decision taken by the authority should be proportional to the objectives sought. तो जो ऑब्जेक्टिव आपको अचीव करने थे उसके प्रोपोर्शनल तक ही वो डिसीजन होना चाहिए, उससे एक्सेसिव नहीं होना चाहिए. So these are the main two grounds, and then it is talking about the cases. So like the one of the landmark case we should use over here is the Menka Gandhi case. So one of the main case you can use over here is the Menka Gandhi case. You can also use this SP Gupta case. Menka Gandhi is the main case basically in which her passport was denied and ultimately the reasons were not given. So it was a clear violation of multiple things. And also you can mention about Ram Javaya Kapoor case as well. So these are the few cases which you can quote to substantiate your answer with respect to the judicial review of the administrative action. That's all. See, in all these questions, if you are clear about the contents, what you should write and how you should write, then this is the way only you should cover your answer. Okay. So first explain what is judicial review of administrative action, under what articles it is being given, then the types, the grounds, and then the judgments. This is the structure of your answer. Now question number 2. Question number 2 is about the Constitution of India has provided for a clear-cut distinction between the civil and political rights on one hand and economic and cultural. Actually, it should be economic, social, and cultural on the other, with a distinct primacy given to the civil and political rights. Explain. So actually, many of the students, they got confused. This is something about international law. No, guys. It is clearly about Constitution of India. Actually, the people basically they get confused about civil and political rights and economic, social, and cultural rights. Actually, the concept is from UDHR. So Universal Declaration of Human Rights, actually they bifurcated the rights of the human beings in two categories: civil and political rights, economic, social, and cultural rights. So they bifurcated these rights into two categories. So after some time, there were two international covenants on civil and political rights and international covenant on social, economic, and cultural rights. So these were the two covenants. Actually, these two covenants, or you can say UDHR, these two parts are actually taken shape. They have taken shape in the name of, you can say, fundamental rights and directive principles of state policy. So actually this question has been given only to confuse the aspirants. So if you are aware about this, how this came into in picture, then obviously you can write it easily. लेकिन अगर आपको पता ही नहीं आया कहां से, तो अल्टीमेटली गलती करेंगे. तो कुछ फंडामेंटल राइट जो हैं, अगर हम बात करें तो बेसिकली इस तरह से क्राइटेरिया इसके डिसाइड हुआ था. तो दिस इज द जर्नल बाइफर्केशन. तो कुछ ओवरलैपिंग हो जाती है, बट जस्ट इग्नोर इट. तो अल्टीमेटली वी हैव टू डिसाइड what is the primacy to the fundamental rights with respect to directive principles of state policy. So ultimately you start with the landmark cases in our Indian Constitution. So first you should mention Golaknath case. In which it was held that fundamental rights are supreme. They cannot be taken away by the government for any reason. And after Golaknath case, we come about this Champakam Dorai Raja case. In which it was also held that once again, fundamental rights are supreme to the directive principles of state policy. But after that came Kerala Education Bill. So in Kerala Education Bill, it was held that there should be a harmonious construction. There should be harmonious construction to the both points. Actually, from the very beginning of this, after independence, because of the socialist policy of the government of India, it was clashing with the private interest. So the public interests were conflicting with the private interest. So in the beginning, courts were of the view that no, fundamental rights are supreme and they can't be taken away or they can't be abridged. But after some time, because of the changing scenario, because of the changing requirements of the society, they also thought that yes, sometimes it is necessary that for the welfare of the public at large, it is necessary that we should make some changes. So fundamental rights should be curbed or should be restricted up to certain extent. So ultimately in Kerala Education Bill, there was a concept of this harmonious construction, and finally Keshwanand Bharti case gave the clarity when it said that no doubt fundamental rights can be amended but subject to the basic structure. So ultimately fundamental rights can be amended subject to the basic structure, should not be changed. And ultimately in Minerva Mill case, the court laid down the proper hierarchy. The proper hierarchy was that all fundamental rights are, you can say, they are supreme except Article 14 and 19. So Article 14 or 19 can be taken away to implement directive principles of state policy, Article 39 Clause B and Clause C, which are about, you can say, equal distribution of resources and about the, you can say, the ownership of the control, ownership of the material of the community. Similarly, Article 39 Clause C was about, you can say, there should be no concentration of wealth. So they were given primacy because of Article 31C. Okay, and then after Directive Principles of State Policy, Article 39 B and C, then we got fundamental rights, Article 14 and 19. And after that came all other Directive Principles of State Policy. So this is the hierarchy, and you should have actually given this outcome in your answer. So basically this is about fundamental rights versus Directive Principles of State Policy, in which it was a clear-cut outcome through this Golaknath case, Champakam Dorai Raja case, Kerala Education Bill, then Minerva Mill case, and even after that you can mention about this Olga Tallis case. Okay. So what I just mean to say, that if you go by the hierarchy, then ultimately at present the settled position is this. So Article 14 and 19, they are subsequent to Article 39 B and C. So they are for the public at large. Public interest is more than private interest. So this is the way you should explain this particular question, because it is a 20 marker question. So ultimately you should write in this context only. Okay. Now moving towards next question, that is Panchayati Raj institutions and urban local bodies have been accorded constitutional status. Explain the ambit and structure of the authority of the Panchayati Raj institutions and urban local bodies under the Indian Constitution. Simple. So obviously you must have gone through this M. Lakshmikant, okay. So you must be very well aware about, first of all, the basic idea was given in Article 40 of Indian Constitution, but that was not sufficient. So finally, few committees were set up. One is, very well, Balwant Rai. In 1957. After this Balwant Rai committee, then finally Ashok Mehta committee was set up. Okay, in 1977 till 78. Okay, so Balwant Rai committee, then Ashok Mehta committee, then L.M. Singhvi committee, then this G.V.K. Rao committee. Okay, so G.V.K. Rao committee was before this actually. Okay, so L.M. Singhvi committee was the final, you can say this was the main basis upon which this 73rd and 74th Constitutional Amendment Act was passed. So due to which we have seen this, L.M. Singhvi committee in 1986 was the main criteria, due to which we have seen this ultimately, the 73rd and 74th Constitutional Amendment Act, by which at village level, at rural level, you can say, and at urban level, we have seen a proper structure So this ambit and structure of these bodies, so you have to just explain now. So ultimately, at urban level, we have been given this Nagar Panchayat, then we have been given municipal council and municipal corporation. Besides these three main bodies, we have been given, further other bodies as well. Like for example, if I say uh, this notified area committee, then town area committee, then cantonment board, etc., then township or port trust, etc., under this urban part, 74th amendment. And when we talk about the 73rd amendment, then ultimately we do have this gram panchayat at village level, then at block level we have been given panchayat samiti, and at finally at the district level we have been given jila parishad. So ultimately, this is the structure. So you have to just explain now all these points one by one, because it is a 15 marker question. So ultimately, you should keep in your mind that this is a little bit historical evolution you should quote over here. And after this, you can bifurcate this and, just urban and rural, you can just bifurcate this and just mention about these particular kind of structure of these authorities under this. And then powers, regarding the powers, so ultimately it is state specific. So as per the state requirements, so these have been given this power. So state governments are concerned with the powers given to these bodies. So this is the way you should write down this particular answer. And that's all about this Panchayati Raj and urban local bodies question. Now, the Constitution of India provides constitutional status and protection to the civil servants. What protections have been secured for the civil servants in India? Explain. मतलब आपकी बार तो यूपीएससी ने मतलब कमाल ही कर दिया, इतने सिंपल क्वेश्चंस मतलब आपकी बार सामने रखे हैं, तो अल्टीमेटली मजेदार चीज है ये सबके लिए. सो यहाँ पर आपको सिर्फ यू शुड बी ओनली कंसर्न विद आर्टिकल 309, 310, 311. So article 309, 310 and 311. 311 is mainly of main concern for you, because it is talking about the what protections have been secured for the civil servants, and then you can mention few cases. Question हालांकि cases में पूछे नहीं हुए, but you can mention that. So ultimately what you can do over here, first explain like article 309, article 310, that actually they work as per the the pleasure of the president. So ultimately this is called doctrine of pleasure. But now ultimately when it comes to the protection given to the civil servant, then you have to quote over here the protection given in article 311. So one of the main protection is that the removal of any officer should not happen by any authority subordinate to them. So ultimately authority only who appointed them, who have the power to appoint them, basically at that level authorities only can remove them. And the second main protection which is given is principles of natural justice. Basically they should be given a chance to defend themselves, they should be given a proper reasonable opportunity. And then you can also quote, because it is a 15 marker question, you can little bit stretch that under article 311 clause 2. There are certain exceptions that in case of national interest or in case of exceptional cases, when it is not possible to hold the inquiry, or even in case of criminal charge, they can be removed without giving such opportunity. Okay, but ultimately you should mention about article 311 mainly over here. And then coming to this about few cases, you can quote over here this Tulsi Ram Patel case. It is one of the main case. Tulsi Ram Patel case is one of the landmark case in this particular point. And then Om Prakash versus State of UP as well. So Om Prakash case also you can quote over here. Okay, two cases are sufficient, but if you want to write down further cases, you can quote this Major SP Sharma case as well. And besides Major SP Sharma case, there is another case, Sunny K. George case. So you can mention those two cases as well. But it will be suffice for you to write down this, because first of all, you have to just mention, because they have been given this constitutional status. So under article 309 and 310, first these two articles, then are the protection, article 311, then few exceptions, and then few cases. So this makes your answer complete. That's all. Now, question number third. Superintendent's direction and control of the elections is vested in the office of the Election Commission, and therefore the appointment of the Election Commission is of crucial importance in conducting free and fair elections. Critically examine the above statement with reference to the recent judicial decision. In our test series, I specifically told all my students, please go through the recent case passed by the Supreme Court. So, Anup Baranwal versus Union of India. Anup Baranwal. So, if you start your answer by quoting that this particular concept of independence of Election Commission of India is discussed by the Supreme Court in the recent judgment अनूप बरनवाल वर्सेस यूनियन ऑफ इंडिया 2023. तो अगर आप अपने क्वेश्चन की शुरुआत ऐसे करते हो ना बच्चे, एक्चुअल में यूपीएससी आपसे यही जानना चाह रहा है, बस एक्चुअल में वो सुनना यही चाह रहा है आपसे, अनूप बरनवाल केस में हुआ क्या था और अनूप बरनवाल केस से पहले क्या हुआ था एंड हाउ दिस इंडिपेंडेंस हैज टू बी सिक्योर्ड. तो अल्टीमेटली व्हाट दे जस्ट वांट टू गेट टू नो फ्रॉम यू. तो वो जानना क्या चाहते हैं आपसे, दे जस्ट वांट टू नो कि आपको पता है कि नहीं रिसेंटली चल क्या रहा है. तो इन केस ऑफ इलेक्शन कमीशन ऑफ इंडिया रिगार्डिंग द अपॉइंटमेंट प्रोसेस, you have to just go into the history. So basically, by just starting your line with this Anup Baranwal case and highlighting this, now you will mention that in 1990 there was one Dinesh Goswami committee set up. Dinesh, you have to just relate the importance of this independence, because starting point was this only 1990, whereby it was discussed that there should be a selection committee. There should be a selection committee. एक selection committee होनी चाहिए. अब क्वेश्चन ये था, if we go with this article 324, it also provides that president will appoint chief election commissioner or other election commissioners on the recommendation by the prime minister. But the point here is this, the selection of this person by the prime minister, by the cabinet ministers, basically the biggest issue is how this person will be selected. So ultimately this Dinesh Goswami committee was emphasizing upon the selection committee. There should be some selection committee. So ultimately after 1990 there was a 70th constitutional amendment bill introduced in the parliament, but ultimately it got lapsed. ये lapse हो जाता है. So ultimately there was no ultimate outcome of this committee. So finally, if we go by the global practice, so it was recommended several times that ultimately there should be some selection body or there should be some expert body like in other countries, in India as well. So we should have this expert body which recommend any person who should ensure fair and impartial elections. So this question has been asked from this particular context only. So in Anup Kumar Baranwal case, right now, recently the Supreme Court has laid down that there should be a collegium. There should be a collegium composed of, you can say, Prime Minister, Leader of Opposition and CJI. So this collegium will select an impartial person unless and until that the moment till the government makes any law with respect to this selection criteria. तो जब तक गवर्नमेंट कोई सिलेक्शन क्राइटेरिया को लेकर के लॉ नहीं बना लेती तब तक आप इस तरह से कॉलेजियम के थ्रू चलो. तो अल्टीमेटली सुप्रीम कोर्ट हैज गिवन फ्यू रिकमेंडेशंस and ultimately this analysis should happen from that place only. So you have to just mention about what actually happened in this case and what is the outcome and how this independence should be ensured. आपको बस ये बताना था, समझे? तो ये क्वेश्चन में इतना ही करना था आपको ये. Okay guys, now legal aid provides a basic tool for access to justice for poor and marginalized sections of society. Discuss and elucidate the constitutional provisions and the provisions of the Legal Services Authorities Act 1987. So guys, in this particular question, first of all, every one of you should be very well aware of Article 39A. Article 39A. And this is also given in Article 14 or Article 22 Clause 1. So you can say this, free legal aid to the poor is a concept of, you can say, these three main articles. So actually what happened, government actually came out with this, after this article 39A. So ultimately 1987, this particular National Legal Service Authorities Act was enacted by the government to provide legal aid. So now first you should mention about the constitutional provisions this way, explain these principles, these doctrines, these articles a little bit, and then come to the provisions of this National Legal Service Authorities Act 1987, which is basically for the purpose of to provide free and competent legal services to the eligible persons. हर किसी को नहीं मिलेगा, it is only for the eligible persons. Okay. After that, it is, along with this, they are about the provision of the Lok Adalat. And the third point is to held legal awareness camps. Now, in this particular question, you should move to explain all these points one by one. So basically, when we talk about the free legal and free and competent legal services to the eligible persons, you should mention that what kind of legal services basically they are providing. So like it is about, you can say, it is about the payment of the court fee. So जो court fee आपको pay करनी पड़ती है, it is about that as well. Then you can say the process fee and all kind of other charges. Then service the fees of the lawyer, or you can say the to get the certified copies. So whatever kind of legal expenses a person has to incur for getting the legal help. So these expenses, and then Lok Adalats are held, the eligible persons you can mention, because it is about the legal aid mainly specifically. You can come to the eligible persons as well. You can mention that women and children are the eligible persons over here. Women and children are the eligible persons over here. Similarly, members of SC, ST community, they are also eligible persons over here. Then the victims of, specifically you can say like any disaster, violence, flood, or you can say this earthquake, etc. can be eligible persons. Then disabled persons, disabled persons. Then also the persons jinki income, the income which is not more than 1 lakh. Okay. However, in Supreme Court committee has increased this up to 5 lakhs. 5 lakhs, you can say. And victims of human trafficking. Victims of human trafficking. So to these persons, this free legal aid is to be given under the ambit of this Article 39A, Article 14, Article 22, Clause 1, just to ensure that justice should be given to the poor and the marginalized section of the society. So by quoting these relevant articles and quoting these relevant, the provisions of this LSA, it is over. So no need of mentioning anything else over here. Okay. So this is over now. Now moving towards another question, that is the strength of the eminent domain is inversely proportional to the strength of the democratic structure of any system. So you should have the basic understanding what is this eminent domain. So the concept of eminent domain has been specifically given under Article 300A. So under Article 300A, we have been given this concept of eminent domain. So this eminent domain is a concept based upon the importance of public interest with respect to the private interest. So if there is a public interest is larger than the private interest, then ultimately public interest should prevail. So actually we have been given two maxims in this regard. So two maxims which you can refer is, one is salus populi supreme lex esto, which means welfare of the public is the paramount law. So welfare of the public, so public welfare is the paramount law. This is one of the maxim. Another maxim which can be used over here is the public interest, that is about necessitia public major est quan. So these are the two maxims about the eminent domain, which simply says that if there is anything, when a private property can be used for the public purposes as a public property, but the condition is there should be a law for that. Number one, the use of the property should be for public welfare and the person should be compensated. So these are the three main grounds actually which are given in Article 300A. So you have to just mention about this, and then you can quote few cases as well if you want to. Like you can quote one case, this Shantilal Mangaldas case. So Shantilal Mangaldas case can be quoted over here with respect to this Article 300A. And similarly, you can also quote this Vasant Bhai case versus state of Maharashtra. So these cases can be quoted over here with respect to explain how this eminent domain is basically talking about that when a private property can be used as a public property for the public welfare, but the person should be compensated. So first of all, there should be a proper law, not executive action. The law should be there, person should be compensated, and another main point is that it should be for public use. So your emphasis should be upon these parameters specifically. Okay, so this is, you have to just mention over here. That's all. Thank you guys. Now next question. What do you understand by the breakdown of the constitutional machinery in a state? Critically examine the powers of the president in imposing the president rule under Article 356 of the Constitution by citing the decided cases on this point. So guys, in this particular case, what one should refer? So first of all, you should mention about Article 355. And then you should mention about Article 356. So the point is, what is the concept of this failure of the constitutional machinery? So when we talk about this failure of the constitutional breakdown of constitutional machinery in a state, actually this question has been taken with reference to two main situations in this country. One is specifically Manipur, and second is about this West Bengal post-poll riots which have taken place in West Bengal. Election के बाद जो कुछ हुआ था. So even recently governor was saying that if you do not work properly as per the mandate of the constitution, then ultimately I have to recommend this president rule. So this discussion, the main point is what is the meaning of the breakdown of the constitutional machinery. For that purpose, you should refer Article 355 and you explain that it is mainly about, you can say, this breakdown, and for that purpose satisfaction word which is being used over here. So if governor thinks that it is expedient to impose president rule, so the discretion of the governor, but with respect to this imposing of the president rule, you should be very clear that the discretion or this satisfaction of the governor should not be arbitrary, it should not be vague. So basically, if we talk about the main case, you can refer over here because it is specifically talking about the relevant cases. So one of the case, SR Bommai. SR Bommai is the landmark case in this regard. So SR Bommai case you can refer. You can also refer over here, this Rameshwar Prasad case. Rameshwar Prasad case can be referred over here. Rameshwar Prasad. But before that, this particular case of state of Rajasthan versus Union of India, this can be also used. And you can refer the recent cases as well, this KK Abu versus Union of India. So these cases you can refer to support your answer, that this, first of all, as per the constitutional mandate, certain duties have been given to the states actually, certain duties with they should fulfill as per the ambit, within the constitutional mandate. But if they do not fulfill those constitutional mandate provisions, then ultimately governor can recommend that president rule should be imposed. Then ultimately president, on the advice of the governor, he should be satisfied that yes, there are certain, there are reasonable grounds due to which constitutional machinery has failed and it is necessary to impose president rule. Then only he can go for that. Otherwise, just on the whims and fancies of the governor, or just on the whims and fancies of the central government, if any president rule is being imposed, it cannot sustain. So SR Bommai case deals basically the duration of 1989 till 1992, whereby president rules were imposed continuously. So Supreme Court has laid down proper guidelines in SR Bommai case how the president rule can be imposed. So ultimately your focus should be upon these two articles and SR Bommai case only. So specifically SR Bommai case, and SR Bommai case is a case which can be used at multiple places. So I advise all of you, if you're preparing to appear next year, please go through this SR Bommai case seriously and read what happened and what kind of guidelines were laid down over here. So that will make your, you can say, this answer complete. Okay. So this is the way you should mention over here. And this is purely subjective matter actually. So there is no specific thing which is mentioned, because Article 355 simply says that if the state is not being carried out as per the constitutional parameters, then only it can happen. So by this way you can just note it down. That's all. Thank you. Discuss the objectives of the establishment of the Lokpal and the Lokayukta Act and their powers and functions under the Lokpal and Lokayukta Act 2013. Examine the effectiveness of the said act. Effectiveness. Actually, this particular question, guys, you can, it is a very straightforward question that you should be very well aware about this Lokpal and the Lokayukta Act 2013, whereby Lokpal in the union and the Lokayukt in the state should be appointed. But if we go by the effectiveness, actually, this body has not been, it is working, it is operational, but ultimately, if we go by the effectiveness, so at present, in many of the states, either the positions were vacant, or in few states, even they were not appointed on time, or even when they are appointed, they are not being given so many of the cases. And ultimately, because of the so many bodies in this structure of corruption, this makes this working of this Lokpal and Lokayukta a little bit difficult. Ultimately, no coordination is there specifically. But the point is, no doubt that Lokpal has done certain things, certain decisions have been, actions have been taken by the Lokpal, and even similarly in few states as well about the Lokayukt. But ultimately at ground level, if we talk about, so the effectiveness is not visible because of the inherent issues in this particular thing. So what you can see, you can mention over here why they were, why it was established. So what was the purpose? So historically, you can mention that ultimately it started from the Sweden. The concept of ombudsman. Because a democracy can survive only when the government functionary works properly without any kind of the bribes, or when they are not working as per their the rules of their services. So ultimately was necessary, and finally in New Zealand, Norway, they have also adopted this concept of ombudsman. So finally it was required during this Anna Hazare movement in India as well, that there should be some Lokpal and Lokayukt at the same footing of ombudsman in the European countries. So ultimately we come out with this act. So you have to just mention about their powers and functions, and regarding this effectiveness, it is actually mixed responses there, because if I go with the number of cases they have dealt, actually it is not so enormous, or not so much of cases are there on what basis we can conclude about whether they are working properly or not. But no doubt there are some inherent issues, so that should be taken care by the government if they really want to improve this structure. But the irony is, if I go with this, if I go to any normal person, a layman, they might not be aware about the Lokpal and Lokayukt kind of system, because it is not publicized heavily. इतना ज्यादा पब्लिसिटी नहीं किया गया इसके बारे में कि इसके बारे में पब्लिक, नॉर्मल पब्लिक को पता हो. That is one of the irony in this effectiveness of this act. But anyhow, just mention all these points, that's all. Now coming to this last part of this paper 1 part 1. So it is about if at any time it appears to the president that a critical question of law and a fact has arisen. Critical question of law and fact has arisen. The president can obtain the opinion of the Supreme Court. So Article 143 actually they are talking about. The role of the Supreme Court in this matter by giving suitable examples. So, till date, actually, President of India has taken the opinion of Supreme Court till date 15 times. So 15 times the opinion has been sought by the President of India from Supreme Court, and there are certain the points which you can refer in support of your answer, like you can mention the situations whereby this Article 143, whereby if President is not not clear about any particular question of law and fact, which should having this the clarity about the highest court of this country. So basically Supreme Court as an expert of this interpretation of law. So in that case, President can ask for this particular kind of opinion from the Supreme Court. However, it is not binding in nature. It is only recommendatory in nature. So you can quote the the examples. For example, the Delhi Laws Act, okay, 1912. So in 1951, this opinion was taken by the President. Then similarly, Kerala Education Bill. Actually, 14 instances were on law only. For regarding the fact, question of fact was only in case of Ram Janambhoomi case. In case of Ram Janambhoomi case, this was the question of fact on which President of India sought the opinion of Supreme Court. Otherwise, 14 instances are there with respect to this question of law only. Question of law. If you mention this particular thing, so this will also give a the positive impact. So even Kaveri water dispute. So we have been given certain instances whereby under Article 143, the opinion of the Supreme Court has been taken by the President. So by this way, you can just relate this, that's all, nothing else. Thank you guys. Now, moving towards part 2, that is about international law. So in case of international law, what actually is given yeah, let us have a discussion about this. So the paper of international law is this part is also very easy. So triumph of the positivism, the school of the John Austin, you can say, has reduced an individual to be an object of international law rather than subject. Comment on the status of the individuals under international law in light of the above statement. Actually, guys, in this particular question, the main point is, if you talk about international law, the origination or the evolution of international law was only concerned with the states earlier. But after Second World War, when the entire world witnessed the mass killing of the normal human beings at a huge level, they come out that there should be some kind of solution, and that solution actually gave that individuals along with international organizations should be a part of international law. But when we come out this positivism school actually says that international law is only a positive morality. International law is nothing, it is just positive morality. And when it says positive morality, it means it is law not made by the superior persons. Actually, it is made by all equal persons. All are equal. Actually, all states are sovereign. So when all are sovereign, then ultimately who will be above the sovereign? So there is no one above the sovereign, and that is the reason all states are equal, and ultimately this international law is not a law as such, it is just a positive morality. And because of this positive morality, that is one of the biggest issue, that international law doesn't have the power as such. So ultimately the individuals, they have become the subject matter of international law, but they cannot enforce their rights directly. They cannot approach before international forums directly. So they should have some kind of relationship with any state. Like for example, they should have some kind of nationality concept. When I talk about this nationality means they should be a national of a specific state. Otherwise, they do not have any rights as such before international forums. So that is the reason this statement is specifically asking that why they are just considered as an object, not subject, because individuals cannot approach directly before international forums. So when you start this writing this kind of answer, so you should start like in the beginning, international law was only concerned with the states. Later on, after Second World War, it includes individuals along with these international organizations, and then you will mention about what is the process, right? Right now how the individuals can approach before the international forums. They can approach only through their states or only through some organizations only. They can't approach directly because of the positivism school, because ultimately positivism school provides international law is not a law at all, it is just a positive morality, and that is the reason behind this issue. So you have to just now conclude about this particular line in your own words. So either they will approach through the states, mainly this is through states only, otherwise in some exceptional cases they can approach through international organizations as well, but ultimately individually they cannot approach. This is one of the biggest issue. Okay, so by this way this answer will be complete. Now coming to this next question, contiguous zone, explain with reference to the Indian practice on this subject. Actually, if you go by the different maritime zones, the concept is for the first 12 nautical miles, this is called territorial sea. For the next, you can say 12 nautical miles, next 12 nautical miles, it is contiguous zone. Actually, from the baseline, it is actually 24 nautical miles. Now, what is the purpose and what is the position of this contiguous zone in case of India? For that purpose, you can refer section 5. For this purpose, you can refer section 5 of, I am mentioning the name of this act, territorial waters, then continental shelf, then exclusive economic zone, and other maritime zones, Act 1976. 1976. Actually, a state has to claim, as per the UN Convention on the Laws of the Sea, states have to claim as per their domestic, as per their municipal law, they have to claim certain maritime zones. So they are not automatically given, they have to be claimed. So India has claimed territorial sea 12 nautical miles, contiguous zone 24 nautical miles from baseline, exclusive economic zone 200 nautical miles, and same continental shelf 200 nautical miles. Now the question is why this contiguous zone has been created. So this answer has been given in section 5 of this particular act. So this section 5 provides that contiguous zone has a purpose of giving a buffer zone to the territorial sea. Actually, territorial sea was created for the purpose of the protection to the land, and then contiguous zone was created for the purpose of protection to the this territorial sea. So as a buffer zone actually. So basically, this is meant for the purpose of prevention of the frauds of customs, fiscal, or you can say to avoid this trafficking or to avoid this crimes or criminal activities which happens outside territorial sea. Because ultimately in territorial sea, the coastal state has full jurisdiction. But after territorial sea, you do not have any jurisdiction with you. So ultimately, few ships actually they used to stand in this area and they used to commit offenses like pirates, or you can say like trafficking, or this drug traffic, drug supply, narcotics actually. So these crimes were committed outside territorial sea, but inside contiguous zone. So basically, to prevent such kind of crimes, this particular zone was claimed by India. So ultimately, if any, the evasion of customs duty, fiscal duty, taxes, tax evasion, or commission of some crimes, if they take place in outside territorial sea, so in such a case, government of India will have the jurisdiction in this area as well. So this is the importance of contiguous zone as per this particular section 5 of this act. So you have to just mention this act, section 5, and you have to draw a chart and then mention why contiguous zone has been created. That's all. Now explain the impact of the recognition on the powers and privileges of the states. Recognition, basically state recognition. So first explain what is state recognition and why it is being given, on what basis it is being given. So once you explain all those parameters of, you can say, the statehood, and then you mention about the recognition. You can mention about the theories if you really want to, but otherwise not required, because you have to just answer within 10 marks. So you can simply come to the main powers and privileges. So basically, treaty making capacity. So once you recognize a state, so you can enter into the treaties with that country. You can have diplomatic relations. Then you can have membership of international organizations. Similarly, you can have access to international courts. So these are the four main points, main parameters of recognition, the power and privileges. So because unless and until you recognize any state, so you can't have such kind of relationship with that particular state. So you just explain all these points one by one. And you can also mention the example of Kosovo. Like India has not yet established any diplomatic relation with Kosovo, but anyhow in future it might. So you can take a reference of this Kosovo as well, and you can mention that ultimately when there is a neighbor of yours, when a country comes into in existence by fulfilling the parameters of the statehood, then ultimately you cannot ignore it. Okay, so you can mention this only. That's all. Now, explain the principles of jus cogens with reference to the Vienna Convention on the laws of the treaties. Over here, first of all, you should be very well aware about what is the concept of jus cogens, which means a preemptory norm. It is a preemptory norm. What is this? I will explain you with reference to VCLT. So basically, in case of VCLT, you can refer Article 2, 6, and you can also refer Article 53 of VCLT, and also you can refer Article 64 of VCLT. So the collective reading of these articles, actually what it provides, it simply says that you cannot enter into any kind of treaties which are in violation of certain preemptory norms. Like for example, you cannot enter into a treaty to promote human trafficking, piracy, genocide, crimes, or terrorism. So you cannot enter into any kind of treaties due to which you promote such kind of activities, because these are the crimes against the human beings, against the humanity. So ultimately, if you promote any criminal activities by entering into a treaty, that treaty will become invalid. So even in future, if new jus cogens principles comes into in existence, even then the old treaties will become ineffective. It is just like void contract. So it is like void agreements. It is just like void contracts. So if you enter into such kind of treaties which are, you can say, in violation of jus cogens, the pre-entry norm, so that will become void. So if you are entering into any kind of treaty which is by default against just cogens. So it is a kind just like void agreement in contract act. Subsequent to that treaty, if any new law comes into in place, new principle, then it will just like void contract. So ultimately, this is all about, you can say, this particular jus cogens principle. International Criminal Court is more of a Eurocentric organization than an international court of justice. Explain the jurisdiction of International Criminal Court in light of the above statement. So basically, guys, this question is pertaining to, you can say, the Rome Statute. The Rome Statute. And under the Rome Statute, we have been given certain articles under which the International Criminal Court has been given jurisdiction. So basically, you have to first explain what is the jurisdiction of the ICC, and then you have to mention about how it is a Eurocentric approach. So actually, the Rome Statute of International Criminal Court provides that ICC will have the jurisdiction upon the crimes of genocide. The crimes of genocide. It will have jurisdiction upon the crimes against humanity. It will have jurisdiction upon war crimes and crimes of aggression. So under Article 6, Article 7, Article 8, we have been given all these parameters. So ultimately, you have to explain these points in detail, like what is the concept of genocide under Article 6. It means when a particular ethnicity or particular group of a person is being killed on the basis of the ethnicity or the race or gender, or you can say like the group. So, these are the points you need to explain. And then you have to mention about how it is a Eurocentric approach. Actually, after the Second World War, all world leaders, they wanted to create one ICC, but it could not be implemented. So ultimately, International Law Commission, they have also recommended that there should be some body like this. So finally, this body was made by a few European countries only, in which America or Russia or China were not a part of that. So even today, these major countries are not a part of ICC. But anyhow, ICC is also more effective because it controls, you can say, the crimes of this kind of serious nature. So by this way, you will explain how it originated, the historical evolution, and then jurisdiction by this. That's all. Law must be stable, and yet it cannot stand still, as it needs to reconcile the conflicting needs of stability and change. And in the fast developing world, the stability appears to have become the casualty in international law. Differentiate between the traditional international law and the new international law in light of the above statement. Actually, this is a kind of philosophical question, and the answer to this question is, you can say, is dependent upon like how you think. In the beginning, it was said that in case of traditional, when we go with the traditional international law, it was more about the relations of states. Okay, but we go with this new international law, which is also composed of not only states, but individuals and international organizations as well, first of all. Now, the another point is the changing dynamics of international law, like how the relations are being maintained. Earlier, it was like only few bodies like WTO by which international law was maintained, because ultimately it is based upon the consent theory and social contract theory. So the fundamental basis of international law is consent due to social contract theory. Ultimately, right now, what we can say that in the new dimension, this kind of, earlier the consent was given that you want to be a part of the society, that is the reason you gave a social contract to each other. But right now, this consent is because of the mutual interests. So in this context, I use this WTO. Like earlier, WTO was the body due to which states, they enter into the, they fulfill this international law. But recently, the failure of WTO, as we know that WTO is a failed kind of concept as of now, but the regional trade agreements like BRICS, SAARC, NAFTA, SAFTA, ASEAN, Okay, these are the successful parameters. So basically what we can say, now the dynamics of international law are changing continuously, and now it is up to you in which direction you can carry on this. So it is up to you now. Okay, that's all. Now moving towards this next question. States show considerable flexibility in procedures whereby they give effect to the rules of the international law within their territory. Explain the acceptability of the norms of international law in India, citing the relevant cases on the subject. Before I start, I just mention one case. Magan Bhai, Ishwar Bhai Patel versus Union of India. This is one of the landmark case. Along with this, you can also mention Jolly George Varghese case. You can also mention Vellore Citizen Forums case. You can also mention this, uh, you know, further, environmental law cases you can quote over here. Gramophone company case. Gramophone India Limited case. Virender Bahadur Pandewala. What is the point actually over here to discuss this particular kind of question? The main point is actually, in case of India, this question is asking about how international law is being applied in Indian scenario, in Indian domestic jurisdiction. This is the question actually. And in Magan Bhai Ishwar Patel, Justice Shah actually gave one important point, that is that any kind of treaty, whenever government of India enters into treaty with any government, in such a case, what we have to see the nature of the treaty. If the treaty is a self-executing treaty, and whether treaty is a non-self-executing treaty. So basically, what you have to figure out the nature of the treaty, that whether treaty is self-executing or non-self-executing. What is the meaning of this? Under this particular non-self-executing parameter, we have been given 4 situations, like whenever there is an impact on fundamental rights, or cession of land, or any burden upon the states. In these cases, actually, if any treaty is being signed by the government with international forums, in international forums, so those treaties, even after ratification, they won't be binding upon India unless and until law is being made by the parliament. So unless and until parliament makes a law, that kind of treaty won't be applicable. But in all other cases, remaining cases, if they are not, if they are self-executing, which does not impact these parameters, so those treaties will be self-executing treaties. So the self-executing treaties after ratification they come into in picture. तो वो सेल्फ एग्जीक्यूटिंग ट्रीटी रेटिफाई करने के बाद ही बाइंडिंग हो जाती है. इवन सुप्रीम कोर्ट ने ये तक कहा है इन वेल्लोर सिटीजन फोरम केस, और इवन इफ यू रेफर दिस विशाखा गाइडलाइंस केस, in many of the cases Supreme Court has referred even those treaties on which even India was not a signatory. जहां हम सिग्नेटरी है वहां तो हमारे ऊपर सेल्फ एग्जीक्यूटिंग बाइंडिंग है ही है, मतलब सेल्फ एग्जीक्यूटिंग ट्रीटी बन जाएगी. जहां पर हमने ट्रीटी साइन नहीं भी करी उसके बावजूद भी that can be a binding thing upon us. Like for example, in case of Rohingyas, refugees, Supreme Court, even we are not a signatory to this convention on refugees, but Supreme Court said that no, principle of non-refoulement won't be applicable in India because even we are not signatory, but we follow in this international fundamental principles as well. So what I just mean to say, you have to just mention about the concept of the state practice used by India to implement international law in its domestic jurisdiction. So you have to just focus upon this Magan Bhai Ishwar Patel case. Rest cases you can mention. In this, the main outcome was type of the treaties, self-executing, non-self-executing, and in non-self-executing, parliament should make a law, otherwise they won't be applicable. In all other cases, they can be applied automatically by the Supreme Court, even there is a vacuum in Indian legal system. So this is the way you should attempt this question. Okay, that's all. Thank you. Now, how do you distinguish between continental shelf and exclusive economic zone? So first of all, make a diagram, make this diagram, okay? Then mention about what is the purpose of continental shelf, which is about non-living resources. Mention that act which I mentioned you, 1976 wala, and then mention the relevant sections given in this act about the concept of continental shelf and the concept of exclusive economic zone. It is about the living resources. Actually, the issue of, even then you can mention the various parameters, like the purpose of exclusive economic zone is about the exploration, exploitation, extraction of the living resources in the water column, So in the water column, this portion. Okay. But when we talk about this continental shelf, it is in the subsoil, seabed and subsoil. So it is continental shelf. The continental shelf is because of the seabed or the subsoil created because of the natural prolongation of the minerals carried on by the rivers in that particular land. Okay, but the living resources in this area, this is the jurisdiction of, this is the ambit of this exclusive economic zone. Actually, exclusive economic zone was known as the exclusive fishing zone earlier, but now it is exclusive economic zone. Now you can mention the extent. The extent of exclusive economic zone is up to 200 nautical miles only. It is up to 200 nautical miles as per the UN Convention on the Laws of the Sea. But in case of continental shelf, it can be 200 nautical miles and up to 350 nautical miles as per UN Convention. Then you can mention the fundamental difference. Otherwise, both are same actually. The only issue is this word exclusive economic zone is a misnomenclature. It is a wrong nomenclature. It should be exclusive fishing zone because it was only about the living resources earlier. And when we club the non-living resources in the living resources, then it becomes exclusive economic zone. But anyhow, now the people usually consider when you exploit living resources, it is exclusive economic zone. When it is non-living, it is continental shelf. This is the way they treat this, okay? So just explain those points and just give the examples. Now, Preamble of the UN Charter is representative of the aspirations of humanity in ensuring peace and security across the globe. First of all, if we go by the recent issue of Ukraine and Russia, we can't agree with this. But anyhow, how far have been their objectives been achieved by the UN explain and elucidate? So this question is very subjective actually. I believe UN is not successful as per my opinion, because I believe if UN would have been successful, then ultimately these kind of wars or conflicts or the hegemony of America or the European powers would not have taken place. But ultimately they are happening. And even the kind of misuse by the China with respect to, you can say, the misuse of its power, the veto power many times. So this is also, you can say, a clear-cut violation of this UN Charter. So, but if I go with this various other, the effectiveness of this this UN Charter. So what I can say, first of all, the UN Charter preamble basically provides that we, the people of United Nations, it is about this peaceful settlement of disputes, no use of power, no use of force. These are the few parameters given in case of this UN Charter. But now the question is whether we are really successful in this domain or not. So for that purpose, you can refer that, if we refer this, peaceful settlement of disputes, no use of force or power. But if we see this Ukraine and Russia issue, and whereby entire world is watching helplessly that there is no solution to this issue right now, and all world leaders are silent on this. They are not taking any action against Russia. Only economic sanctions have taken place. But for what promise they have entertained Ukraine regarding that, inclusion in NATO, this is also not happening. So ultimately, this entire world is suffering, and similarly, same kind of situations as are happening in other parts of this world. So ultimately, it is about this ensuring peace and security. Now, you can just mention your opinion about how this peace and security No doubt, peaceful settlement of disputes by the various methods, like the negotiation or good offices, conciliation, mediation, or arbitration or ICJ, they are effective. But ultimately, in ICJ, this is one of the biggest issue, that it is not a compulsory jurisdiction, it is optional. So many countries, they have left out the ICJ jurisdiction. So do you think that really, they are following UN Charter, and the parties, that the states who are part of this issue are the all developed countries? They have left the compulsory jurisdiction of ICJ. So I believe the response is mixed. When it comes to the developed country, so they implement their hegemony and they just violate all these norms. But when it comes to the developing or the underdeveloped country, so they are following these things. So this is the way you can just write down this answer. Okay, it is purely subjective, so you have to just give this answer with respect to these recent examples only. Okay, now reservation in a treaty, reservations. So I hope you must be knowing that in case of any, you can say, like a treaty, states can enter into a treaty as per their the process of VCLT, but sometimes they take a reservation. Like India has taken few reservations many a times. So what is the impact of those reservations actually? So ultimately, when we talk about the concept of reservation, so what we can say, that how the reservation can be taken and what will be the impact of the reservation. So explain the circumstances under which the reservations in treaties are permissible under international law. So guys, basically, what is the concept of reservation? The simple concept of reservation is that this particular point won't be applicable in my case. So this is the concept of reservation. So ultimately, Article 2D of VCLT defines reservation. What is reservation? And in case of reservation, if we go further, so what we can say, that reservation is meant for the purpose of, like the foundation of international law is on the basis of consent. Foundation of international law is purely based upon the consent. So because all states are sovereign and you can't force any state to enter into a kind of you can say, like treaty. So earlier there was a concept of like a traditional approach and Pan-American approach. Under the traditional approach, if any state is taking a reservation, then that state won't be under the part of you can say this reservation, this treaty. तो अगर किसी पर्टिकुलर स्टेट ने कोई रिजर्वेशन लेने की कोशिश करी, तो दैट स्टेट वोंट बी एबल टू गेट दिस this reservation with them. So ultimately what happens in Pan-American approach, or you can say universal approach, now it is the outcome that if any state is taking a reservation, because international law on the basis of consent, every state due to sovereignty, they have their full freedom, full choice. So ultimately you can't force them that you should accept this condition. So ultimately when any treaty is being signed or negotiated, so this concept is being given to them so that they enter into the treaty with their mutual consent. So when you talk about this reservation, so you can simply say under what circumstances. So if the any provision of treaty is impacting their sovereignty or national integrity, or if it is not suitable to the needs of a particular country, or not it is not permissible as per the domestic law of that country, in all those cases this reservation can be taken by that particular country. And as per Pan-American or universal approach, if any state is taking a reservation, so that particular point won't be binding upon that particular state. So this is the concept of reservation, that's all. Under what circumstances a recourse to the force or aggression permissible and justifiable under international law? Article 51, and this question is basically with respect to Russia-Ukraine conflict. So Article 51 is the main article under which the concept of, you can say, recourse to the force or aggression is permissible. Even Under the ambit of UN Security Council, collective action is also permissible if we refer further articles of UN Security Council given under Part 7. So even under those Part 7, under various provisions, even collective action can be taken. But the main point is self-defense. So right of self-defense. So when there is an imminent risk, danger to the sovereignty of a country, okay, the reasonable apprehension. So in that particular case, proper force can be used to prevent that particular risk. So this is Article 51, and you have to just explain this. And specifically, I advise all of you, you should mention about this Russia-Ukraine conflict so that you can relate that how Russia, on the name of the anticipatory self-defense concept, they have taken this action. So this is the point. Okay, so you can just simply refer Article 51 and Part 7 of this UN Charter, under which UN Security Council can take collective action to justify this particular point, nothing else. It is very simple, straightforward question. WTO provides a platform for agreements among state members, which forms the legal foundation of trade. Critically evaluate the importance of WTO in the new international economic order. Actually, if I go with the recent situation, then I do not agree with this statement. But anyhow, you just mentioned. Actually, you can start with two main lines. There are no friends, no enemies, only mutual interests. ना कोई दोस्त है ना कोई दुश्मन है, सिर्फ अपने अपने फायदे देखे जाते हैं. सेकंड, when goods do not enter, soldiers will. तो जब गुड्स का ट्रेड नहीं होता, सोल्जर्स एंटर कर जाते हैं, लड़ाई झगड़े शुरू हो जाते हैं. तो अल्टीमेटली अपना अपना फायदा देखा जाता है. तो अल्टीमेटली दिस क्वेश्चन इज टॉकिंग अबाउट हाउ द WTO World Trade Organization is effective in, avoidance of Third World War, because ultimately which matters is interest, your own interest. So in this particular case of WTO, you have to just explain why in 1945 it came in the name of GATT, and then finally why it became WTO, and what is the importance of WTO to maintain a proper flow of trade among the border, beyond the borders. So why trade happens? Just mention this line and just mention how WTO is effective in this. So WTO has created a kind of environment in which proper, liberalization has taken place, and tariff and non-tariff barriers have been removed or reduced significantly, opened the door of economic liberalization among nations, and due to which now all states are living peacefully, because na baap bada na bhaiya, sabse bada rupaiya wala jo concept hai, that is the reason. Okay, so that is the reason now many world countries are looking for India, because now they are considering India as an economic hub. So that is the point. Okay, otherwise it is having a lot of issues, WTO, right now. Now moving towards, member states of the UN need to take appropriate action for protecting and improving the human environment. In light of the above statement, highlight the major steps of the UN for protecting the human environment. Actually, regarding this this climate crisis. So in this particular question, this is a very, you can say, like infinite kind of answer can be there of this question, because it is about protection of the human environment and all UN efforts. So from the Stockholm conference, from the very beginning of the Stockholm conference, you have to just mention about all kind of like environmental protection laws or the conferences which have taken place. So Rio conference, UNFCCC, okay, Stockholm conference, okay, so you have to just mention all those treaties in which various all treaties or with respect to environmental law, you have to just mention each of them. If it is possible, then limit yourself with respect to the marking scheme, because it is a 15 marker question. So at the max you have to write down 200 words. So in this way you can just write down limited kind of treaties which you remember, or the recent, the conferences which have just happened recently. Okay, so UN framework on this climate change is one of the biggest thing which is happening, and so these kind of treaties you can just quote over here and nothing else. So in, just mention the major steps. So only those treaties will be sufficient in this answer, not technicalities are there. Okay, that's all. Now, last and final question of this session, paper 1. It is about international humanitarian law is a set of rules to limit the effects of armed conflict, whereas international human rights law seeks to ensure a set of rights which are essential for the survival of humans as humans distinguished between international humanitarian law. Actually, this question is about international humanitarian law versus international human rights. In my test series, I have given this question many a times just to make all aspirants understand that this is one of the main question UPSC asks many a times. So in this question, you have to first explain how international humanitarian law came into existence. So basically, you can say this creation of ICC was the major step with respect to the war crimes, genocide, crimes of aggression, okay, so crimes against humanity. So when all such crimes are being committed, so in this case, basically what happens, ultimately these are the crimes or basically war crimes during the war. So international humanitarian law is applicable during the war time. So during the war time, there are certain laws which are being made because of, in the ancient times through the these Geneva Conventions and Hague Conventions regarding this, this convention on the no use of these biological weapons or chemical weapons, or you can say like the dangerous weapons causing loss to the humanity at large, human beings at large. So basically, the initial beginning of these international humanitarian law is on the basis of the Geneva Conventions and then Hague Conventions, and ultimately, after that, at present, this International Criminal Court is the, you can say, like the body which takes care of IHL. So ultimately, there are certain rules made by the, by such conventions that during the war time, what kind of methods you can use for the war, like no use of war, no use of chemical weapons or biological weapons, or no unnecessarily mindless killing of the people, and no attack upon the these Red Cross the persons of the Red Cross Society who are serving the human beings in the war. Similarly, no crime, no killing of the wounded person, no killing of the this the persons, the killing of the normal human beings should not be killed in the war. So ultimately, combatants, non-combatants. So ultimately, non-combatants should not be killed in a war. But combatants, when they are, they do not have weapon with them, and ultimately when they are wounded or they require medical assistance, they should not be killed. Even the treatment of the prisoners of war. So basically, we have been given certain conventions under which such rules have been laid down. But when we come to the international human rights, it is about during the peace time. During the peace time, when there is no war as such, so ultimately, what are the various rights available to the individuals? So basically, we call them human rights. So civil and political rights, economic, social and cultural rights. So basically, these are the various rights which have been enshrined over here. So you have to just differentiate between these rights one by one, and that's all. So this question will be over like this only. So that's all. Thank you guys. Thank you for your patient listening to me patiently. Now we will meet in the next session regarding the paper 2 discussion. Thank you much. Thank you very much.